Yesterday, attempted murder accused and alleged cartel member Vusimuzi Matlala was back in the hot seat as he continued giving his testimony at the Madlanga Commission. The eventful day began with his legal team arguing for a postponement. His legal team also threatened to approach the courts for an interdict to halt the Madlanga Commission proceedings should their application be denied. Now, following a brief adjournment, the Commission rejected Matlala's bid for that postponement, paving a way for him to continue answering questions. However, he remained adamant on invoking what he believed are his rights against self-incrimination. Well, to unpack these developments, we're joined by Professor Kholofelo Rakubu, who is a criminologist at Tshwane University of Technology. Prof, a pleasure having you. Thanks very, very much for joining us. Let me jump straight into it. I mean, did we advance anywhere yesterday after Matlala's evidence?
It was we expected bombshells, but we did not get. Silence was the strategy, and silence is common in organized crime. And I think South Africans got to understand or even learn the meta principle, which is more common in mafia criminology. But then I will dwell into Matlala's concern about self-incrimination because it's legally understandable, because he's not merely an ordinary witness. He's simultaneously, we understand, simultaneously accused person confronting ongoing criminal proceedings, but the right against self-incrimination cannot automatically become a blanket shield, because that's where he was trying to go. Against every difficult question. It cannot. The critical issue then, it should be whether each particular answer create a genuine risk of criminal exposure, and also what immunity attaches to compelled testimony. Criminologically, I therefore am less interested in the fact that Matlala is refusing to answer than in the pattern of those refusals. What is it that he's largely refusing on? Because he adopted a selective exposure strategy. If silence consistently emerges around money, police relationship, procurement, and communication, it begins to map a sensitive point of the alleged network, right? That does not prove guilt. It tells the investigators where independent corroboration becomes indispensable, because in this case, he doesn't want to talk, he doesn't want to answer, then it also assists in that refusal to answer. It is a directive. His silence is very loud, if I were to say so, because it assists investigators understand where is the tip of the iceberg, where is he refusing, because he's highly selective. But I would say, dwelling into constitutional rights, then that is more of a protection, more of a strategy, protection and strategy, and selective disclosure largely.
So I'm interested to see what you think about, obviously his advocate announced yesterday that the legal team could withdraw, but Matlala said that he'd given no such instruction. In fact, we're waiting to see what happens at 9:30 this morning if the legal team actually arrive. But, you know, what does this breakdown do to confidence in the preparation and management of the evidence?
Yes, the management of evidence and the caliber of a witness. I think this is also challenging to the legal team as well. And him going against the legal advice as well in that manner shows that there's conflict and there are issues behind closed doors and they do not agree on certain issues. But again, I see his legal team more interested in the legal debacles, the debates and so forth. But again, at some point, I think he's largely relying on the self-defense. He's trying to avoid, he's trying to evade, he's trying not to answer. And today, I do not think this legal team will win or manage to convince the commission otherwise. And I think the commission then today will largely have to move away from generic questioning, because I don't think we are now interested in knowing whether Matlala knew people or communicated with people. We just then have to trace the money. We have to trace communication and benefits largely. What was it in for him? Because we cannot be questioning whether you know this and that, you know individuals in particular. Silence suggests he's aware, silence suggests protection, and silence, like I said, is common. Today is just to then move to evidence-led investigation. Take him to page numbers, take him to his testimony, talk to facts, and then move, because he's not going to give it us anything. And the legal team, his legal team is ready to debate. And that is also a delay tactic, because at the end of the day, we lose sensible testimony and discussions while we focus largely on who then knows the law better, who has a clear legal argument, than asking talking to the testimony and evidence on the table. I think investigators have done tremendous job today. They must just take him to task, take him to facts, and try to then move with it in evidence-led investigation or testimony. Take him to points, corroboration, and so forth. Don't ask him about, do you know, have you met? No, they are WhatsApp texts. Talk to those WhatsApp texts. They are telephone calls. They are bank statements that will then corroborate or even suggest otherwise. That will then lead us somewhere, because otherwise we will debate the whole day. But then he has a sensible concern about constitutional right, but that cannot be a blanket approach to every difficult question. He must answer.
And there's a time limit to all of this, and we're heading there swiftly, where we talk about the 11th of September, and this information is needed. And I want to get to some of the information that actually did come out, because we'll leave all the legalese and fighting and wrangling to them themselves. But there is this admission that he met Shadrack Sibiya several times and attended his son's engagement, but denied any friendship, and then refused to answer allegations about the cash and impalas and all of those things. How should those partial admissions be tested against recordings, financial evidence, and Sibiya's earlier testimony?
If now he claims not to have a friendship, I guess WhatsApp communication can prove otherwise. A chain of emails, but I don't see Matlala as an email type. Telephone calls and transactions, because we're largely interested in the benefits. What kind of information did he receive that can be verified from Sibiya, if there's any? But then to establish a relationship, that will be a bit difficult outside WhatsApp text and communication. But then how do you say you're not friends when you have been invited to such intimate gatherings? That will be difficult for Matlala to dispute if there's more evidence coming to forth. But then we're largely relying on verifiable information, such as WhatsApp communication, extensive calls, if they are there, and I believe they should be there. And again, communication with other people that will then include information from Sibiya through Matlala, that will then strengthen argument around relationship, because there are elements of relationship here. You just don't invite people, you just don't give them more information. And again, I'm interested in the my person analogy. Remember, there's still pending my person analogy, where there's so much speculation around who's this my person, and with evidence and all the papers on the table, it looks like my person becoming the police commissioner at the time might be Sibiya. So that will not be a bit difficult to prove, but commission will have to then deeper to then prove against his testimony that no, you met on this time, you called and you received the following. And I'm hoping financial statement can also link him to Sibiya.
Yeah, I mean, the commission, the second interim report has already recommended criminal investigations into the likes of Shadrack Sibiya, Fani Nkosi, Witness G, and Brown Mkhotsi. If we take Matlala's evidence into consideration, what can it really add, and what concrete action must follow these hearings?
Obviously, criminal investigation, and with criminal investigations, I think South Africans are also interested in the aftermath, criminal investigation, and then what? And again, we should be on the know with regard to the final product. They have been taken through the processes, but then what is the final result? What is the end result? Because I guess most South Africans are interested in a different end result where one will serve a sentence. And for us to know if one served a sentence is thorough communication and feedback with regard to the Commission's recommendations.
So when we look at also one of the other issues is the idea that he's denying close relationships with cartel figures, and this is a big thing because people are wanting to know who, how, what, and he says he knew some of them only through introductions. You know, does this selective answering that we're seeing coming from Matlala weaken him as a witness, or can investigators establish the alleged network without his cooperation? Because I imagine it's important that we get this from him.
They should then establish the network without it. He's not going to cooperate. He's not going to cooperate because there's retaliation fear, there's network fear that Matlala is showing. With retaliation fear, the consequences from the network itself, he cannot be perceived as cooperating with authorities, right? So there's that fear. And also network fear, a fear of implicating your friends and officials in the SAPS and so forth. So such a person with that kind of fear, on top of that is legal fear because there's ongoing criminal proceedings. Then there are three fears: your legal one, your network one, and your retaliation fear. So such a person will not collaborate. Therefore, they must then adopt a different strategy to utilize evidence, even to also critically analyze his silence or his selective disclosure to then go proceed, because he's not going to assist, he's going to evade. And we know with organized crime syndicates, they know where to spot or identify powerful legal representation. So we're seeing with Matlala, he has strong legal or prepared legal representation.
Yeah.
Why so? Because of the magnitude of implication and also what is at stake. His life is at stake. Organized syndicates is at stake. The so-called big five is at stake. So this is a huge task for the commission to then establish all that with Matlala's silence, to critically be able to analyze Matlala's silence, because silence is in organized crime is evidence in itself.
Yeah, and it could stand for protection, because it does in a way. Yeah. You kind of reading into the fact that he may be protecting alleged criminal dealings and criminals, in fact. Just quickly, very, very quickly, to wrap this up, the battle over the affidavit made during his abandoned plea negotiations. Talk to me about the challenges here, because this serves as a big challenge. If we could do that quite quickly, just to wrap this up.
He cannot come in today because that was taken under oath, right?
Yeah.
Then now to come in to say, I want to nullify what I've said before, that also is a strategy, because now he understands the commission's angle and point of departure. Then now when you subsequently want to nullify, then meaning you lied under oath. The minute now you want to revoke, right, then it means you want to nullify, and that cannot be. So what the commission received initially, it is believed to have been received because he was under oath. He was being honest. So you are practically saying I lied, or I decided to exclude certain information not to assist the commission. Practically, you are saying I am a very dishonest witness because I provided a dishonest testimony initially.
Prof, thank you. Thanks so much for talking to us. Professor Kholofelo Rakubu, Criminologist, Tshwane University of Technology, talking to us about the latest developments out of the Madlanga Commission.